All right, we're going to move on to our combined hearings. All right, these are the combined initial hearings, and I'll ask everyone to come forward on that. We have Sharon Irwin and Shadayra Kilfoy-Flores. Also, if you are here, to please come forward. All right. All right, these are the combined initial hearing and the separate matters of the complaints of Sharon Irwin and Shadayra Kilfoy-Flores against Police Chief Michael Koval, each dated August 12th and served by stipulation through the respondent's attorney. I am Commissioner Wes Sparkman, President of the Police and Fire Commission. At this table with me are the Commissioners Campisher, Yap, Hamden, and Trammell, and PFC Counsel Scott Herrick. We conduct this initial hearing pursuant to our Rule 6.08, and we combine them for administrative convenience for this section only. Would you state the appearances, please?
Mr. Chair, Al Matano, counsel for both complainants.
Sharon Irwin.
Shadayra Kilfoy-Flores.
Lester Pines of Collin, Weston Pines of Balcarrel. He appears for Chief Koval.
Does the respondent wish to file an optional written answer to either complaint?
No.
Does any party anticipate filing any written motions prior to the evidentiary hearing itself?
Not on our side.
No.
Okay. All right. And when will complainants be able to disclose their intended witnesses and exhibits?
Is now too soon?
Well, it's not too soon, but the question is literally a time question, so the answer would be now. But don't disclose them quite yet.
Okay. Answer the question that was asked.
Yeah.
Okay. And when will respondent disclose intended witnesses and exhibits?
I would like 3 weeks. So today's the 12th. I think would be October 3rd.
No.
Actually, I'm going to actually need to, it can't be 3 weeks from today.
Okay.
How about the 7th of October?
The commissioners, any thoughts about that? Okay. All right, how much hearing time do complainants estimate will be required for their case?
And let me clarify here, since this is going so smoothly, I feel I need to do something to interrupt it smoothly.
I appreciate that.
There actually are 2 cases at this stage, so at this point, we're talking about schedule, how much time for each case. So on that basis, what do you have to say?
Well, Attorney Herrick, I'm new to the process, and I'm not certain that we'll be able to reach all of our witnesses, but I would estimate 1 to 2 hours, really.
For each case?
They're parallel, so why don't we say 2 hours for the Irwin case and 1 hour for the Kilfoy-Flores case?
Should I ask Mr. McConnell a question?
Sure.
How many witnesses do you have?
Well, we have about 3 core witnesses and 2 or 3 others who we would like to get if we're able to obtain their appearance. And some of them were just asking a few factual questions, like, what did you see? How did you, so it won't be like trying to get them to crack on the stand and confess to being the real murderer.
You won't be trying to crack your own witness.
Sure.
So maybe possibly a little more than an hour or two and a half hours. Maybe.
Simply so.
3 hours, yeah,
So
3 hours.
Oh, so 3 total. Okay. All right.
So I'm sorry, is that just 3 hours for the presentation of your case in chief? Or does that include the case as presented by the defense?
I was assuming it included the defense.
Okay, I just wanted clarification.
Of course, Attorney Pines would have a better idea how much time he
It's always hard, because I don't know what they're gonna say.
Right.
So, I mean, I'm not known for lengthy cross-examinations, but if we got 6 witnesses and whomever the chief may call, 3 hours seems like it's probably not gonna be enough time, so. But I don't know, this is always in the evening, right?
Pardon me?
This is always in the evening. Is it
Yes.
al- Yeah. And we always start at 5, around 5 o'clock? Okay.
We can shift that to, to 6, but it doesn't
No.
change dramatically.
I mean, I think probably 5 or, it's very, very hard for me to estimate, because I'm really doing it in the dark, so.
Well, the next question is, how much time apart from cross-examination do you anticipate for the defense?
Let's say an equal amount of time, and if we can make it shorter than that, we'll do that, because to start at 5 o'clock and then at 11 o'clock is a lot of citizen members that come. So let's say a total of 6 hours for the hearing, and if we can do it, it is from the chief's standpoint, if I can make a more concise presentation, I'll do my best.
Okay.
And I think this is a fairly contained set of facts, so.
That was my thinking, that what we're arguing over is not, it's fairly contained.
The commissioners do not have a large volume of experience being confronted with the circumstance of counsel having stipulated the facts. But if by some miracle that might happen in this case, that would be delightful. So it is a contained set of facts. There are perfectly good reasons for everybody not to do that, but there may be stipulations that can be satisfactory all the way around. That would be fine. I would just remind you that you can do that.
It's always a good evening.
Is that something the parties are interested in entertaining at all? Because if you are, then I think we need to talk about setting a deadline for that meeting. I know.
Can I make a suggestion?
Sure.
Why don't we say that, we haven't set the date for the hearing, but let's say that 1 week before the scheduled hearing, the parties will attempt to stipulate to those facts which are not contested.
Certainly.
Okay, commissioners, any thoughts about that? That's fine. Okay. Is there anything further from any party? Okay, all right, that our attorney, Scott, will issue a written.
Well, we'll look at a date.
Okay, so we're all checking, right?
It's Mondays, right?
Not necessarily.
Oh, okay.
But that's the regular meeting date, but for a hearing, it'll be something special. Why don't we go off the record for a moment while we just look at calendars and figure things out? Yes.
Okay.
Can we we go back on the record to put that on the record?
Everybody ready? Okay. All right. And the date, Scott, that we determined?
Off the record, we set the date of November 16th for hearing. And we identified the date of October 28th as the deadline as between the parties for sharing a stipulation of fact, or reaching a stipulation of fact. We anticipate 6 total hours for hearing. I want to clarify something that wasn't discussed explicitly, but seems to be implicit. And I don't want to over-formalize it, I just want to be clear about it. We're talking about this as if the hearings in these two matters will be consolidated for hearing purposes. Is that a fair summary of what everybody is thinking?
Apparently so.
It appeared to me that would be the case, yes.
Okay. That's perfectly fine. We'll sort that out administratively as we go along, but we'll consider it to be consolidated for hearing purposes.
Okay. All right, now Attorney Scott Herrick will issue a written scheduling order reflecting the calendar that we just discussed. And this matter is in recess until we convene for evidentiary hearing.
Thank you.
Thank you.